This is bringing new questions about potential competition, for instance, which was for a long time less well regarded in the competition analysis than now. Also, conglomerate mergers are raising much more discussion. So before we thought of conglomerate mergers as not posing many questions, it's now posing more and more questions because most of these mergers are really not about the same product market, but they're related product markets and not necessarily vertical, but they're building up on an ecosystem perspective and reinforcing the network effects and economies of scope and scale that was just mentioned in the prior panel. We are also seeing more and more data-driven mergers. So we're seeing more mergers that are really even not with related products necessarily, but with related data. And that's bringing new perspectives on analysis of mergers that I think we need to take up as well. And more discussions on innovation theories that came more from this hard science discussions of like pharma or even agrochemicals, but now they're moving into digital, and we're thinking more of the harm to innovation and the dynamic discussions of the impact of mergers on innovation in different digital markets, which are not necessarily, I believe, the same as, for instance, in pharma markets, where you have like this pipeline of research coming up. So we need to think of innovation in different ways in different markets as well. Here. But these are just some of the challenges. We're certainly going to hear much more on that. And I'll go straight to our panelists who certainly will bring interesting thoughts on this. So let's start with Björn Lundqvist, Professor of Law at the Law Department at Stockholm University. Thank you, Björn, for your comments on this panel.
I will do a short introductory presentation, I guess. And I actually have some slides. I'm going to talk a little bit about the new power of platforms and the implication of merger policy. And I'm going to do a little bit from this point of view, but focusing mainly on the second level and data in the end of my presentation. Honestly, this is a part of my presentation which I would like some input on, and I also included this a little bit in actually the BRICS report, so that's why I'm curious to see what you think of it. I think there's different form of arenas where you can see the power of platforms, and the first arena is the competition or the arena between different sort of platforms, and even though the platforms provide very different services, they somehow, in many ways, compete for our interests and our attention on a general attention market. And that is the time, if you look at individuals, the time we have actually to be on the internet and be available to use our attention to different sort of services. And even though they provide different sort of services, Google, Amazon, Facebook, and so forth, they do want us to be on their platforms and be on their sites and also be included in their ecosystems. And they do really want us actually to, if we want to leave the service that they are providing, the platform, which is the central hub of the ecosystem, they want us to go, yes, somewhere else, but hopefully inside their own ecosystem. And that is the first level. So there is some kind of competition between different sort of platforms and between different sort of ecosystems. And I can already now, I think, in such a general attention market, I think it's quite difficult to find market power in certain ways. But on the second level, I think there is also the issue of what I try to call it like intra-ecosystem competition. Like there are system competition. Like inside the system or these ecosystems, then the platform and the system leader controlling the platform has genuine power to control that kind of ecosystem. And that is due to the fact that they provide a platform, the hub of the ecosystem, that has tipped, so to say. That service has tipped, and they are the one who are almost a monopolist in that service, or in a notion or in a position where the winner takes most. And then we have data, which we already touched upon a little bit, which is the Internet of Things, the idea that everything going to include a sensor which is going to pick up data from us. And that, of course, will affect the way that platforms compete in an inter-platform competition, but also how the ecosystems and the intra-competition or the intra-ecosystem is going to work out. What implications might this have that? If we look a little bit at data specifically, we have often talked about the notion that there are exclusive data sets, which a certain firm can pick up and become the owner of, so to say, or the controller of. I wouldn't say owner, because no one owns data. Data is like the air we breathe. But controller. Often those exclusive information sets or data sets, they often belong actually to governments. The data set for trademarks, or the data set for corporate information or something like that, which actually they were, on the EU law, were ex-ante regulation telling these authorities that they need to provide that to the market. But there's also others. We will talk about the car industry, I think, tomorrow. Of course, the car industry, they collect all the data, what we do in the cars. That is an exclusive data set that normally goes to the producer of your car if you have a new car. And that's somewhat of an exclusive information, exclusive data set. That, of course, creates some kind of power. If you have exclusive data that no one else have access to, then you have some kind of power. But also there's non-exclusive data. And often when people present about merger control, they say, well, there's going to be a lot of multi-homing. There's going to be a lot of data out there which everyone has. And that is, of course, true. But inside, I think, ecosystems, if we talk about, if you're a company stuck inside one of these larger ecosystems with one system leader controlling that information that you might want to get access to concerning your customers, for example, if you sell your stuff on Amazon, who they are, what age groups are they in, and so on and so forth. Or if you produced a film or a series on Netflix and you want to know who's actually watching your produced show, then that generally speaking, that information might be generic, but of course for you is quite exclusive. So I think we need to look at that a little bit, that power can also be built within the data, within this ecosystem, and there, even though the data itself, if you look upon it purely objectively, it can be non-exclusive, it can still be somewhat exclusive inside the ecosystem. Then there are, of course, theories of harm which you can connect to this. Of course, in a merger situation, if you combine two data sets so they become exclusive, that could create an absolute foreclosure, which could be an antitrust harm, which you can identify, and could be a way then to actually address this merger. But there can also be relative foreclosure, depending if these firms are locked into these ecosystems. And the question is then, what can a competition authority do? Can we have some kind of data access remedy in place? And data sharing remedies, I think, are quite difficult to impose now. We could do it. One issue is standardization, which we touched upon a little bit at the first panel. We need, data is not standardized. There are initiatives to try to use the same kind of language, to standardize data formats. But it's not. It's a huge task. And in the EU, we tried it since 2003 with the first PSI directive, and it's quite difficult actually to standardize data formats. APIs is the same thing. Better standardized at the moment, at least, than data sets, but it's a difficult issue. We also have data protection issues, I think, and the right to be forgotten. This was an issue which was raised quite early, and I've raised it since 2016 almost, that how, when you actually use data protection rules as a defense for not sharing data, and you are a large collector of data. Let's say you're a car manufacturer, collect a lot of data. You hold that data about the driver. Another firm wants access to it. Let's say it's actually the owner of the car. It's the bank, because the banks own the cars, because you normally lease a car nowadays. So it's a new car, you leased it. The owner of the car is a bank or a leasing firm. They want to have access to the risk profile of their driver. Nowadays, the car manufacturers have that. They can pretty easily understand if this guy speeds too much or brakes too much. And can then the leasing firm get access to it? Often then the car manufacturers are actually putting forward data protection rules as a showstopper not to access that kind of data. And that this is also something that could be played in merger regulation. We can use competition law often to access property, intellectual property. I mean, in Europe, we have this exceptional circumstance doctrine. In a very few rare cases, you can use competition law to trump intellectual property law. We haven't really seen it against data protection rules. Can we use competition law to trump data protection rules? And especially when it comes to data sharing remedies in this case, but also under Article 1 or 2. Also, another remedy, I think, is the creation of data commons or data pools. Can you use a data sharing remedy to say, well, you're allowed to merge, but then you need to give access to all and everyone to the data sets that you're creating for the future, which is quite an issue, I think. But there's certainly some remedy problems here. That was it. I'm done. Thank you very much.
Thank you very much, Björn. This is quite interesting. I think data poses new issues, both on designing theories of harm and understanding how mergers can negatively impact the competitive environment, but also, and I think I made a good point on that, it poses new challenges for designing remedies. It's not easy to design remedies around data and sharing of data. So I think we can discuss some more on that as well. So with that, I ask Ujjwal Kumar from Quds International to make his presentation. Thank you very much.
And very good structure given by John, and we'll try to follow that in the Indian perspective. But I'll begin with what I was provoked by Paulo, that competition policy, in fact, is an inadequate tool to deal with inequality or big tech or things like that. I would rather like to see competition policy and competition law connected but different entity together. Competition law may be inadequate, but competition policy is not. Competition policy is something very wide, and we look other policies from the competition glass. We look even industrial policy, including IPR policies, trade policy, labor policy, or even data policy. So whatever pro-competition outcome can happen from a policy, this is a whole of government approach. So it's a very broad and it's very strong, and it can have a very good ramifications to control inequality, to control, to enhance access to small businesses, to do businesses and things like that. Even competition law, I would say generally in Indian law also, and perhaps most other law, are very broadly worded in that sense, and if they follow the objective better and if they kind of develop certain tools, many of the nuances of the digital economy can be taken care of, including mergers and acquisitions. For instance, Indian law's objective is to, in view of the economic development of the country, authority has to kind of check appreciable adverse effect on competition, has to sustain competition in the market, to look into the consumer welfare, and also to see that the free flow of trade and commerce is happening. But in view of the economic development of a country, and the word development is used and it's not growth. So development is basically variable for both growth and equity. So if an authority wants to interpret its law, they have a broad set of tools to interpret. It may be the political tools, or it may be the kind of lack of expertise or resources that may be preventing them, but perhaps not law to that extent. When it's come to merger and acquisition, we should see that this is also in a very competition law is basically ex post facto solution to anti-competitive practices. And in this post facto solutions, mergers and acquisition is largely an ex ante tool to see that after the merger happens, there is no kind of competition concerns remain in the market. So largely it is a ex ante tool in itself. In the mergers and acquisition, first thing that comes is that threshold, whether it will qualify for the merger review by the authority or not. And here comes the problem in the digital sector, because most of in Indian law, the problem is in Indian law, in the sense that it is kind of based on turnover and asset, and as Paulo has said, that is a very low investment in the sense, but high. So that does not necessarily qualify for the merger review, mandatory merger review. In that sense, recently, government had set up a competition law review committee to review the law, whether it is sufficient to deal with nuances of including the nuances of digital economy. And it recommended that deal value or transaction value can also be included to determine the threshold. So that will in a sense bring down that concern that a digital merger may not qualify. However, it has also recommended and it has already been included in the law that there will be a green channel for merger and acquisition. That if parties feel that there is no competition concern, so things will be clearer in very near future what it will be. So whether government will accept deal value as a threshold will not, we will see. Relevant market, so far authorities have largely not been in 14, 15, 16 digital merger cases. Most of the cases they have not defined relevant market and found that largely that there is no kind of competition concerns. However, at the competition assessment stage, some good thoughts have come, and thanks to again BRICS Academic Forum on that. On the last report of food and agriculture, when the global mega mergers were also going, and this was in the debate in this and this forum, and we saw that competition authorities of the BRICS taking lead in innovating and giving some kind of innovative conditionalities to approve mergers. Particularly of that was Bayer and Monsanto. FAS took the lead in the sense, and they saw kind of not only the agriculture products, but they also found that there can be a digital platform market in agriculture to give farming solutions and from that also was one of the very important part of it. And Indian authority also learned from that and in fact Bayer had to agree that they will give access to say agroclimatic data and will not discriminate the Indian entities on their platform if they come to. It's a very futuristic kind of and innovation was also the whether market will be innovative or not after merging entity. That was also taken into account. So of late we are seeing that the innovation is happening within that same legal framework. Legal framework has not changed lately, but that's happening. So I'm very optimistic that tomorrow, if very data concerned things, and there can be if that is in the theory of harm, which has not yet been taken into in any merger cases in competition law so far, but I think that can happen and will be recommended. Because I'm saying this because the Competition Law Review Committee has recognized that Indian law is sufficient enough or broad enough to take into account network effects or control over data while determining the dominance. So though Competition Authority has not yet taken those into account, but it can take into account in the change scenario. So I'm hopeful that if tomorrow a merger or acquisition happen in the digital sector, say for example like Grab or Uber in Singapore, if the same kind of thing happen in India, I'm sure access to data or data control will be one of the kind of will be one of the conditionalities put on that if it is allowed. It would be very tough to allow. Conglomerate effect has also been recognized by the CLRC, the Competition Law Review Committee, and has asked. It's in the report. So I think the Competition Authority will now be more serious towards vertical mergers and conglomerate mergers as well, and will kind of scrutiny. So basically, the whole approach, again, the competition policy approach seems to be to deal with winner takes all situation doesn't arise in future, and have ex ante solution. So from that angle, the digital strategy is also kind of coming up simultaneously, which is yet to settle. Largely, the India is what seems to be most of the documents at this moment of time is in draft form, yet to be implemented. But what is emerging as if kind of there would be some control over flow of data, there will be a kind of enhanced access to data, and perhaps it would be also be like that the data of Indians would be kind of those of the Indians, and if foreign entities kind of approaching that data, that have to be on certain terms and conditions. But this may be unlikely, or this may be a trade-off between the kind of the growing protectionism in the world. So lots of trade and investment agreements are also happening. So this may be a kind of a negotiation or bargaining chip that India might be keeping. But largely India, in terms of monetizing the data, and wants its own globally competitive platforms to come up. So for that, access to data is one of the kind of emphasis on that to enhance their data. That will be a pro-competition situation in that sense. So let me kind of stop here, I think.
Thank you very much. I think very, very interesting comments as well. I think just one comment on the issues of thresholds. I think there's been quite a bit of discussion on thresholds lately on whether there is the current thresholds are not sufficient to catch the mergers that should be looked at by the competition authorities, and whether we should move to transaction value as one potential threshold. I think that's certainly one possibility. Some countries are implementing that. I do think that there are other possibilities as well, and that we need to consider them as well. For instance, in Brazilian law, there is a possibility of the competition authority up to 1 year after the transaction to request to review that particular transaction. Of course, there's a problem of ex post review, but many times some of these transactions are very publicized, so it actually could be required to be filed very close to when the transaction is being announced. So it would be a possibility of screening these transactions more actively and requesting to file transactions that are potentially harmful. I think that's one of the possibilities here. We saw the European Union also in their report referring to as the referral system, right, as a way of screening this at the national level, and whenever the potential transactions is problematic, could be referred to the competition, to the European Commission, which I think is also another alternative. So I think we need to be creative here, and we need actually to deal with how to bring these transactions to analysis of the competition authorities in different ways, which I think is quite interesting to work on as well. But let me pause here and move forward so that we can keep our discussions and open the floor as well. So let's have now Professor Svetlana Avdasheva, head professor from Faculty of Economic Sciences and Department of Applied Economics at HSE. So thank you for having us here, and thank you for participating in this panel.
Thank you, Chair. I'm very proud to be a part of the project and to contribute to very interesting discussions. Let me share with you some thoughts about what competition authorities should do within merger approval towards platforms, towards digital platforms. I completely agree with Professor Azevedo that actually the targets that competition authorities should achieve are very traditional. Competition authorities should solve three traditional questions: to assess competitive impact, to elaborate theories of harm, and to identify efficiencies. Within the merger. Second, to decide which decision is best, and third, to decide how to achieve this right decision within merger notification, within a merger approval. And here to solve these three very traditional questions, all our knowledge, and not only our knowledge as industrial organization theorists or competition economists, and not only our knowledge in law and economics, but sometimes very intensive knowledge in strategy, in strategic management, and technologies are required. And here all the features of multi-sided platforms that were mentioned by Professor Pereira, which are cost structure and network externalities and matching and innovation character of business models. All these specific features are very important to be taken into account. That's why a new power over a platform is important in order to be addressed very precisely within the merger approval. So first target is to delineate affected markets, and here all the knowledge about platforms influence the conclusions on the markets affected by the merger, because it's especially important within complex ecosystems, which are already mentioned during the discussions, because within value chain or within ecosystem of multi-sided platforms. Part of the participant in the ecosystem could be at the same time customer and the competitor. Application developer within operational platforms. Is it competitor or is it customer? At the same time, it's developer is a competitor and customer at the same time, and this should be taken also into account. Then, if we have theory of harm or competition concerns, competition authority may address these competition concerns with merger remedies. It's not accidental that Björn immediately jumped to remedies that could be issued within merger analysis. And it's especially important for BRICS competition authority because at least 3 competition authorities within BRICS group, which are Russian, Chinese, and South African authorities, do not fear to issue very extensive remedies, both of structural and behavioral or conduct types, and also intermediate type of remedy about IPR, about compulsory licensing, and so on and so forth. So, BRICS competition authorities actually have a large toolkit to be used when developing merger remedies. So, one important question: what kind of remedies could be appropriate to promote inter-platform competition or intra-platform competition? Because content of these 2 types of remedies could be very, very different. For inter-platform competition, the issue is comparatively easy, and even very limited remedies, like for instance, ban on any restrictions on multi-homing could be of importance in further development of the markets affected by platform. I have very small example of Russian remedy towards joint venture of Uber and Yandex, and the most part of remedies was that FAS considers any restrictions on multi-homing as illegal, and it's and there is a ban on any form of single homing, explicit or implicit, in taxi aggregator market. What do we see after the remedy was issued? Is it accidental that 3 months after the remedy was issued, a relatively large rival entered the market? It's a city mobile that now controls for about 20 to 25% of Moscow taxi service market, and it was just after the remedy was issued. I don't know. Some people say that in taxi market, platforms cannot support single homing, and multi-homing is a natural in this market. I don't know, but probably FS remedy still plays some role. What we do have now in this market, we have the evidence that a large part of Moscow taxi drivers actually use multi-homing. They use different applications, different platforms, and share their working time between different aggregators. We also have very aggressive pricing strategies by these aggregators. We have a steadily decreasing price for taxi services and very fast increase of the market amount of market turnover. At the same time, we see a wave of new mergers in this market both between Yandex and smaller participants and between smaller, medium-sized and smaller market participants. What we cannot predict? We cannot predict what would be an equilibrium outcome in this market, which effect will dominate, effect of easy entry when multi-homing is supported, or effect of positive effect of economies of scale that makes larger company more competitive. We do not know, but in the short run, remedy actually plays some role, and customers benefit from competition. Of course, the issue of remedies in order to support intra-platform competition. This issue is much more complex and much more difficult because here competition authorities should consider platforms as owners of essential facilities, and actually they should impose requirements for them, like requirements for the owners of essential facilities. And here there are many very difficult questions. And just first question is, what is essential facility in this market? Is this data? Is this ability to provide information? Is this ability to provide connection? Is this ability to provide code of operational systems? And this decision, what is essential facility in this case? Is principle to elaborate an effective remedy if competition authority wants to do that. Well, there are again two questions here. First question is how to identify this essential facility. I think that one experience of Russian competition authority might be useful, and this is experience of attracting third parties to discuss so-called codes of fair practices. Russian affairs has an experience, sometimes very successful, sometimes not so successful, to attract market participants in order to discuss conditions of fair competition and fair business practices in particular sectors. These discussions could be very useful exactly in technological advanced industries where knowledge of competition authority could not be enough to understand the issues of competition. And the second question is a choice between conduct or behavioral remedies towards a platform and legal acts that Professor Azeveda has mentioned. About standard setting, open standards, data protection, and so on and so forth. On the one hand, yes, general laws could be could have larger impact because it's a general. On the one hand, there are circumstances where when a legislator is not absolutely certain that these general legal requirements are really necessary and they do not impose unnecessary burden on smaller or medium-sized market participants. And in these circumstances, or in the circumstances where a legislator or competition authority wants to impose asymmetric regulatory burden, to regulate a remedial burden only on larger market participants, in these circumstances, probably in some cases, behavioral remedies could be useful toolkit to protect competition in the sense of intra-platform competition. So that's all I can say. Thank you.
Thank you very much, Svetlana. This was very interesting. I think remedies keep coming as a very important issue. I think thinking of remedies on inter-platform competition and intra-platform competition, I think, is particularly useful. The example of multi-homing, I think it helps us thinking through what could actually decrease barriers to entry and keeping an industry or a platform open to inter-platform competition. I think that's particularly interesting. And on intra-platform competition, I think there's also some traditional measures of non-discrimination that's also being adopted. Like Brazil had a recent case on a platform for investment where a bank acquired a platform that is open for investments. It was kind of a supermarket of investments, XP. It's called, and one of the requirements of the authority was a behavioral requirement of keeping it open to investment products from other banks as well, so it's not vertically integrated there. So this is more of a traditional non-discriminatory remedy in intra-platform competition in this particular case. And of course, there are trade-offs in between intra-platform and inter-platform competition, like in this case, for instance, keeping the platform open for all banks might actually increase the network effects of that particular platform and make it grow in a way that would make it more difficult to have inter-platform competition to a certain extent. So that's always something that should be also part of our discussion here. But one thing that maybe we could, in the discussions with the floor later address, is this relationship between this panel and the prior panel on this asymmetric regulation strategy of sometimes whether this could be implemented in merger cases, right? I mean, because it's asymmetric and it's focused on certain companies, maybe there is room in certain cases to implement certain behavioral remedies there. And I think that's a big question mark, whether the merger field is the best way to do it or it's the appropriate way to do it. And that ties up also with Yanni's comments on how the merger discussion is also a bargaining discussion. It's also a moment where companies need an approval, so they may be more willing to negotiate remedies and behavioral adjustments at that point. So maybe we could advance a bit more in this discussion, fleshing out what are the problems and the concerns in going in this direction there. But let me pause here and let's have Alexey Ivanov, Director of the BRICS Competition Center, and the HSE-Skolkovo Institute for Law and Development.
So I would address two basically questions related to this. First, is globalization platforms as global phenomenon and as economists, as Paulo was teaching us today in the morning, that it's inevitable they're going to be big in the digital economy because of economy of scale and scope and other things like this. And that's one topic I want to raise. Another topic is a balance between behavioral structural remedies and basically this alternative, ban it or open it, like this platform. So what to choose and in which particular circumstance. So for the first question, I think it's extremely important to understand that there is a battle, basically a struggle between authorities and the big businesses in terms of all sorts of techniques in terms of like how to avoid scrutiny and antitrust control for merger, and they use number of techniques like arbitrage, strategic filing, using a lot of procedural arguments like procedural fairness, due process, stuff like this, trying to find a way how to avoid basically scrutiny. It's not to comply with analysis, it's not to cooperate with authority, it's rather to skip the control which installed by antitrust laws in most of the jurisdiction. And I think it's a very important part of the discussion, because previously when we had less globalized economy or globalized economy in a different way, when economy was operating on a global scale, but at the same time not at the level of enterprises. So enterprises were not that globalized when everything was simultaneously global, like consumption, production, interaction. So at that moment when during industrial economy, let's say, before it became digitalized, companies could afford to go at different pace in different countries, and at the same time authorities were kind of creative in approaching mergers, and there were some negotiations on local levels. And at that moment we saw a huge rise of this call for collective call by business community to the competition authorities to unify procedures, to be like predictable, to be transparent in terms of what type of analysis they do, what type of remedies they're going to impose, and through all sorts of fora like ICN or OECD, we could hear that authorities have to implement a certain clear procedural framework. So to be procedurally simple, to be procedurally transparent, that was the call, and that was the demand of the business community. And authorities, to a very large extent, did satisfy this demand. And we see that in mid-2000s, most of the authorities imposed very strict procedural rules with regard to mergers. And in most of the authorities, timelines are very short, so kind of rigid. In Russia, for instance, quite difficult to extend your timeline if you follow the laws, of course, as they're written. And same in many other authorities. We hear from South Africa that 60 days and no more. Like any case, in each case, when they go further the deadline, they under kind of serious public pressure and legal pressure as well. So where did it bring us? It brought us to a situation when basically authorities are very restricted in terms of cooperation, because they mostly focused on complying with their deadlines, with their procedures. But at the same time, the global businesses, they require kind of quick response from a number of authorities at the time. And businesses didn't become that globalized in their... So they synchronized authorities in terms of procedures. They didn't synchronize authorities in terms of substance. At the same time, businesses, they don't want to apply globally, so they try to apply still on local levels with different set of data they provide to the authorities. And we saw it in many mega mergers when companies coming to authority in South Africa and provide this amount of data, to European Union that amount of data, and to Russia like completely different set of information. And those informations could be even contradictory, could be covering different parts of their businesses, and could be like, let's say, highlighting different topics related to more like local dimension. So as an outcome, we see a growing outcry on the side of authorities for companies to be more transparent and more synchronized in their applications, in their filings. So that's one thing, and I think it's a very important thing, because there is no clear solution how to proceed. Because if things would go as they are now, we could see probably more this type of bargaining things happening and more unpredictability for businesses as well, but also more kind of pressure on the authorities in the logic that they're becoming too much industrial policy driven rather than competition policy driven. And it's easy to become. It's easy to become when you don't see the whole picture and you don't see also, and you're not treated kind of as you're not dealt with in terms of competition law analysis. Because sometimes you don't see the whole, basically, landscape. You don't see how the company really operates. They don't open you data about the operations abroad in different countries. And we saw it, for instance, in the case of Uber-Grab merger in Southeast Asia, when a Singaporean authority did clear the merger with some remedies. Companies didn't give a damn about those remedies, so they didn't comply. Singaporean authority was saying, hey, you promised me to comply. Look, I put these remedies. They say, okay, but we basically had different plans. So they from the very beginning, they didn't want to comply. So they imposed fines. Those fines were up to, $15 million, but they raised, $6 billion in funding at the same time for this particular merger. So basically, Grab raised like $6 billion, paid $15 billion, nice deal. Good deal, basically. Why wouldn't they do it next time? So all the incentives showing that it's better to basically bullshit to the authority, I would use this type of tough word, but because it's local, it has limited power. To find this type of violation, they have to go deep into your filing. They already forgot about what it was because different people. That's one thing. Another thing is basically toolkit we have. And toolkit is an important thing because all the companies saying we expect remedies to be operational, really like implementable, effective, and so on. But at the same time, authorities are not, they're lacking capacity to analyze development of the automotive sector and how automotive sector uses data, how they utilize what's really necessary for automotive sector in terms of like data access. And because of restricted deadlines, basically, I think all the authorities, they come up with a very simple choice. Either they crash the deal, so they block the deal, or they kind of try to open up a little bit the structure which supposedly related to platformization of economy. So this choice is extremely politically sensitive in most of the stories. And either if we do not reform the interaction between platforms and authorities, maybe making the process of filing and assessment of those mergers longer, more flexible, giving authority more bargaining power in this sense, we wouldn't any time reach a point when remedies would be well fitting, the disease, the problem which they have to treat. So when authorities deal with this crash or open dilemma, I think for most of the sectors right now, we heavily underutilize this crash option. Underutilize it although there is a huge potential for this, because, for instance, in Russia, Svetlana was mentioning these deals happening in taxi hailing area. They did impose behavioral remedies because they were scared to block the deal between Yandex and Uber, scared because of all the same type of rhetoric that you deter innovation, you deter development and it's anyway happening. So if you put a ban on development of the sector, it would anyway break the dam. So it would flow through and so on. So all these digital platforms would emerge. They impose behavioral remedies, but after City Mobile, another competitor was rising. Actually, it was poured with a lot of financing from VTB banks or. They started to implement a strategy which would effectively avoid complying with those behavioral remedies. For instance, Yandex Taxi was banned to impose this multi-homing restriction. Okay, you have to use different platforms. But if you spend on the Yandex taxi platform more than, 8 hours per day driving, you get discounts. You get preferential rate. So means effectively they all want to stay at Yandex taxi because they otherwise. Is it this thing they kind of avoiding this restriction? Very difficult to prove and very time consuming to prove. So FAS has to go and prove that they not complying, and if they don't comply with this, okay, another fine. It's not something they're interested in. But now in Russia there is another merger ongoing where Yandex is they got appetite after they merged with Uber. They got Uber. Now they're trying to buy another taxi hailing platform, which is the biggest regional platform. It's the second biggest platform actually right now in Russia. It's called RuTaxi, Vizyot. It's the name of the company. So it's more like economy class taxi hailing service, cheaper than Yandex. And there is one competing actor, another one Get, and another one City Mobile. So basically there are 4 corporate companies of this type in Russia. So Yandex, after it bought Uber, they got appetite in buying more and more because they saw that behavioral remedies they negotiated about, for this merger, were not really constraining them. So they want another one, and they are raising money for this, and they buying a cheaper option. Uber was cheaper than Yandex Taxi. After they bought Uber, they annihilated competition with a cheaper competitor. They're now going for even cheaper one. So they're going down. What they're doing, they basically want to destroy all the alternatives. So there is a certain strategy which I think implied in the minds of this business type of organizations, of this platform organization. You have to buy everything which is alive around. If you don't do this, don't stop. You have to go until the end of the market. You have to reach the bottom. You have to buy everyone. And we see it actually with a number of other companies. Google was doing the same. Facebook is doing the same. We don't see exceptions. We don't see when these platforms stop and say, okay, we're done, we're full. No more interest to consume. No, they can digest everything. They can digest the whole market. And until they have unlimited supply of funding, they will do this. Why stop? So if authorities start blocking, actively, putting burden of proof to the platforms. You didn't prove us that it would be, efficiency. It would be necessary. It would be inevitable that you have to kill these guys. They would never stop. So in this sense, I think authorities have to, in a current condition, in current environment, in current circumstance, they have to stop thinking more about adjusting remedies, because those remedies would be anyway inefficient, considering the process they're dealing with the companies, considering the toolkit they have, time they have, everything, how market operates, inefficient all the time. Remedies would not work. So just start blocking. Just block. If you see something really persuading, some arguments coming, if platforms really persuade you that it would, then allow, then you can let it go. But I think, for instance, we have to try. And some authorities, for instance, FAS, why wouldn't try to block more deals in digital economy to preserve competition which we still have? We have a little bit of competition in taxi hailing industry. We have competition in search. By the way, search, we have competition. But Google wanted to buy a Russian search engine, Bigun, back in 2010, when Yandex was not that big that time. Bigun was quite substantial, and FS blocked the deal. So they were already showing interest in blocking the mergers in this digital very nascent stage of search engine market. They blocked the deal. They didn't allow Google to buy Bigun, which was Russian search engine. As an outcome, Yandex got bigger. Yandex got bigger share. So we do have competition. Very few markets in the world, probably maybe it's the only market where we do have competition in search. In China it's alternative monopoly, but in Russia there is a search competition in search market because they blocked the merger. Why wouldn't they block more? That's my question. I'm done, thanks. Sorry.
Thank you very much, Alexey. I think we're advocating for more of a rebooting the system than really just upgrading it, right? It's kind of like, let's rethink about this. But I do think it resonates with a lot of the discussions on creating certain types of presumptions against certain types of mergers that would be rebuttable presumptions, so it could still prove that that particular merger is efficient, but in certain circumstances, it would be a presumption against a merger, which is a way of articulating a legal rule that is flexible on one hand, but that would shift the burden in some types of these mergers. But let's now open the floor for questions and comments. I think it's an incredibly interesting panel with many different issues on the table that we could discuss. And fortunately, I got a message here that our lunch was moved forward a little bit. So we have about 20 minutes to discuss here. So the floor is open, and I think we should gather 2 or 3 comments or questions and then have the panel respond and then get another round, just as with the prior panel.
My name is Kaushik. I am from India. I am a professor of economics at a university in Bombay. Just a quick question about the multi-homing thing that you both talked about. And Alexey, I take your point about how it's in reality not really possible, or maybe the regulator doesn't want to get into the details of it. I just wanted to add some color from the Indian perspective. There are 2 rival, dominant ride-sharing services in India. And you talked about how on the consumer side, if I understood it right, that on the consumer side, consumers are given discounts if they're on the Yandex platform for a certain amount of time. To me, what seems even more pernicious is what happens on the driver side. And in the Indian context, the pricing that drivers get isn't really linear. And so as they spend more time on the platform, they earn more money, exponentially so, not linearly so. And in many cases, to break even, they have to do 10 hours or 12 hours on only one of the platforms in a day. And they can't really switch between these 2 platforms. And it just seems interesting to me that the conventional wisdom, if you talk to drivers, if you talk to consumers, not so much consumers in the Indian context, but definitely drivers, is there is no multi-homing. Yeah, of course you can switch, but in reality nobody switches. I'm just confused why regulators in India and in Russia aren't taking notice of this. Is there something else that's missing, or is it really your argument that it's too difficult, it's too time-consuming, the talent and the money isn't there, so we're not going to get into it?
Filippo?
Yeah. Hi, I'm Filippo. I'm a fellow at the Stigler Center at the University of Chicago. I have a question for Björn, I think, that maybe is also for Svetlana. So I think that one of the foundational insights of the Chicago School has put like this is that whenever you have inter-platform competition, inter-market competition, you don't really need to care about intra-market competition. You can allow firms to organize their own markets the way they believe more efficient. And that's the foundation behind GT Sylvania and a lot of different cases that really allowed freed companies to like limit distribution within their own systems and things like this. And from what I understood, Björn, you're kind of saying that you have inter-platform competition in these markets, but then you have intra-platform lack of competition that's problematic. So I wanted to understand, why do you believe this is problematic in digital markets more than other markets, and why?
We have Paulo and Giacomo, and we can wrap up this round and have comments from all panelists.
I will bring a data that is in the report. It's very related to the discussion of the session. We have more than 100 acquisitions by the big techs recently. And when we say that there is this intrinsic move to grow due to economies of scale, network externalities, we're not saying this is organic growth. We're not saying that is the additional effect of acquisitions. So my point is, what's the basis for allowing this amount of acquisitions? It seems to me that the definition of the relevant markets is playing a crucial role here. So very narrow definition of relevant markets. Even the recent discussion about Facebook, so they redefined the market in a way that Instagram and Facebook are not in the same market. So again, if there was an acquisition taking the regular approach, it would be approved nowadays. So my question is how to address that, and what's the behavior, what's the role of cooperation among competition authorities in a structural remedy, because it's more difficult to impose in such cases.
Giacomo Calzolari. It's a very actually related point. So I was thinking about Facebook, WhatsApp merger 2014 that was cleared by European Commission. That's been debated a lot. So in the retrospective, what can we say about that merger? Was it a good idea? Well, ex post is very simple to discuss and say and have opinions, and even strong opinions on this. Ex ante, what was the business model of WhatsApp by that time? We don't know. And to some extent, it turns out that they didn't know. So, to some extent, I saw you smiling. So what I'm saying is that here, I agree with Alexis that so authorities should be pickier in blocking mergers ex ante, but we need bold new tools, at least it's my own opinion, to revise mergers ex post, because these markets are changing so quickly that we don't have so many informations, the information that we normally need to evaluate a merger as we normally do ex ante. And so we really, I think, need to look forward and see ex post after some time and reconsider cases.
Thank you very much. Excellent questions.
I'll start with Filippo's question. In the presentation, what I tried to present was this different arenas. So it's not really a market, I would say. There are also, I guess, markets where we have these network effects and where they're tipped and where there's tipping going on. And I think a difference, and I'm no economist, but there seems to be a difference between markets in the digital economy compared to the more global, let's say, old economy. And that is when there is network effects, especially indirect, but also direct network effects, and they tip, they seem to create quite strong monopolies inside their systems. While in the old economy, there seemed to be the end game seemed to be more of an oligopolistic system where you actually have more firms. So I think if we can agree there is inter-platform competition where there's perhaps no dominance because they compete for our attentions and so on. But then, of course, there are specific markets for specific services that they provide, like search services and so on. And these are, I guess, those markets that can tip. But they do also have, we need to acknowledge that they also have control over the ecosystem surrounding that. And taking Amazon, it perhaps is the best example, where they do control a lot of the business users using Amazon. And I think we need to take that into consideration, that they have system power, system control inside our system that should be taken into consideration when we do merger review. And it's early ideas, and the question is how should we do that? Because in many ways we view them as vertical mergers, so we view them as conglomerate mergers, but we do have some ideas about aftermarkets and so on that we might be able to use which could be developed, I guess, to view some mergers that we today view as vertical mergers or conglomerate mergers, to actually understand that they are perhaps aftermarkets or connected adjourned markets to the merger. I think I stopped there, actually.
Yes, very briefly. Multi-homing, yes. I mean, we have also found from our own survey, yet to be published, that multi-homing on the driver side of a taxi platform is really much less than, and the reason is exactly the spot on that. In initial years, they used to multi-home because they used to get incentive from both, and an incentive structure was very liberal in the sense that was basically a freebies given to the driver to attract on the platform to create the network effect. But of late, when the network created and critical mass achieved, the regime for the structure for incentives becomes more kind of stricter, and hence one has to. So that's multi-homing from driver side. I think the authorities need to do a survey to get that data. Okay, you are saying this, let me test. Let that time period not be included in the time period of the kind of merger and acquisition procedure. Secondly, on Facebook and WhatsApp and Facebook, Instagram, again I would say perhaps consumer survey to be done. If they would survey me, I would say that I was on Orkut, then Facebook came, and then I switched on to Facebook without even closing formally the Orkut. I never been on the Instagram. I am now more on the WhatsApp, very less on the Facebook. So these kind of information authorities can get, but the kind of now the we also have to see that WhatsApp is not a sustainable model, economically sustainable model. While Facebook is perhaps cross-subsidizing it to sustain. So these are the issues. And secondly, in the last panel it came, Elena, that data can be a relevant market. If data is a relevant market, then there is a conversion. There is a overlap.
About multi-homing and mechanisms which support multi-homing, I'm not so pessimistic about these mechanisms. When I was downloaded third application in my iPhone, every second suggestion of driving I receive with discount. I think almost every client understands this option, and that's why on the side of customers, on the side of clients, multi-homing is very useful. But I also think that taxi drivers understand this issue as well. And actually, during last years, as I know the fraction of earnings that taxi drivers keep in their hands is increasing exactly because of multi-homing in Moscow, in Moscow taxi market, and I think they understand the mechanisms which support this. About de facto and the Euro multi-homing and single homing that Alexey mentions. I trust a little bit in our competition authority. I trust that FS is able to discover the effective single homing requirement in terms of higher discounts, as FS did that. You remember in Google Android case, the case was essentially the same. There is no an official or contractual restrictions on multi-homing, but in fact, single homing was effectively supported by financial conditions, and FS was able to discover that and to give assessment to this fact. Very interesting point. Why we do need intra-platform competition is very important point. I think there are two very short answers. First, because why just Another question: why we claim that Gazprom should provide non-discriminatory access to other gas suppliers in Russia? But we claim. So the answer is like that. It might be the case that this intra-platform competition brings efficiencies and requirements for non-discriminatory access. I completely agree that crucial words are exactly non-discriminatory access might be welfare improving. So, and of course, I completely agree with the point that our knowledge might be insufficient, my knowledge insufficient for sure, to identify all the markets affected by merger. And it's very, very important and very difficult task to, that's why it's so difficult to give a proper assessment of competition concerns within the merger. Thank you very much.
I just add two things, not eating much time from our lunch. So one thing is about market definition, certain reluctance to block the mergers when you see that multi-homing requirements wouldn't be observed. I think there is a huge problem with the discourse, and I think it's more a symbolic thing, more things from the sphere of ideas and thoughts rather than of how government works. It's like there is a huge scare, to make a mistake. To make a mistake which would deter innovation, which would deter, development of these platforms. And we see this cycle, we see this kind of mindset within the authorities because it's coming from business, expert community, and it's actually related to a question of dominance in the market of ideas, which we totally neglect in many contexts. There is no merger for acquisition of academic minds. It should be also filed and cleared or blocked with some remedies maybe cleared. Because many academics or experts in a broader sense, they are acquired to a certain extent. There are relations, established institutional relations between major beneficiaries of the digital economy and those who are supposed to criticize those. And this relation is pretty much neglected by the regulatory environment. And that's, I think, also one of the answers why we still so much caring about market definition. Why we still understanding that things are very different, markets operate very differently. There's no sense to spend time calculating this, market boundaries. Just doesn't make any sense. But authorities preoccupied by this enterprise, they're doing this exercise all the time. Burning taxpayers' money, by the way, on this, and time, which is very precious. So that's, I think, very important, I would say, very important barrier. That's basically the ceiling they can't break, which is to think a little bit out of the box. They're too much preoccupied with the current toolkit. And if we solve this, other problems, I think they would be solved consequently.
Thank you. And I think part of the issue with the toolkit is really designing, and Paulo, to address your questions, really designing better ways of looking at conglomerate mergers. I think in these markets, what we're seeing is conglomerate mergers have an issue, and we need to understand them better. It's an issue of reinforcing network effects, acquiring new customers. It's an issue of growing economies of scope. It's an issue of increasing barriers to entry. It's an issue of aggregating data. There are many different levels where we need to look at these conglomerate mergers in ways that we never looked at conglomerate mergers, actually. Authorities always looked at conglomerate mergers and said, well, these are a good one. Usually not a big problem. But now what we're seeing is these ecosystems are really conglomerate ecosystems, but they reinforce each other in ways that we're just beginning to understand. I think that's one of the issues that we need to look deeper. I think time for a couple other questions or comments.
So just to, I think the chair did mention about thresholds, and I just wanted to quickly highlight, something again from speaking from an Indian perspective, but I'm pretty much sure this is applicable globally as far as BRICS countries are concerned. That the WhatsApp Facebook merger didn't get scrutinized as far as India was concerned because of a technical de minimis threshold, which is a revenue and an asset-based threshold, which, of course, many of these the new age companies don't have. So I was a part of a panel of the government which re-looked into these matters in the new the committee. We kind of looked into Germany's example of a deal-level threshold. Again, there are mixed signals as to how far that has been successful. So I would very one of the, apart from relevant market definition, how do you have thresholds in terms of assessing many of these new age mergers? And the quick point to the comment where I was very happy to Alexey to note that the FAS has the political strength at least to block mergers. I can talk about my country's example. The merger control part was delayed by almost 2 years, not through a court process, but because the government was very afraid as to how the bureaucracy will react to and stop mergers. And, the first chairman has actually been on record that he had given personal assurance to the then Prime Minister that there will not be unnecessary blocking of mergers. So to what extent BRICS countries typically, because, you are competing with an ease of doing business index and various other such sort of platforms to attract investments into your country, to what extent is the political will to regulate mergers, as you were talking about, can be extended on a general basis to other BRICS countries?
Okay, I just say that you're exactly right. There is this competition of different policy approach. So on one side, everyone wants to be ranked higher in the World Bank, doing business ranking, and for this they try to reduce the scope of methods and authority has, tools authority has. At the same time, they require authorities. There is a political demand for authorities to be more active in analyzing market and implementing certain measures. So it's exactly a political problem, and that's why I think it's important to speak about this in a political sense. So not just to discuss technocratic aspects of how to measure this particular behavior or this particular concentration trend, but to speak about this as an threat, existential to a certain extent, threat to the economic well-being of the country, because investment climate is considered. What is investment climate? Nobody knows. But everyone is raising this point all the time. Like any meeting of the ministers of government, say, we have to improve investment climate. For this, we just need to lower the taxes on big guys, or something like this. So the solution for improvement of investment climate could be absolutely whatever. So it could be anything if you link it to investment climate, to a big thing, to a big idea. So you can go with this. With competition, is a little bit different, because when you narrow down the scope of competition law application and say, we're not about something big, we're not about inequality, there should be something different, other spheres. We're not really about attracting investment. We're not really about it. We're just about some strange stuff which nobody really cares about on political level. We call it competitive process, efficiency, whatever. You have to elevate your sphere in terms of political necessity. So to call it, we deal with inequality, guys. We can solve this problem. Then you wouldn't have the pressure, as you mentioned, from Prime Minister of the country. Think so. No.
Just a very short comment on this. And I recalled I worked with Health Ministry, and this matter came when lots of our domestic pharmaceutical industries were being acquired by multinational. Our position was that we should allow greenfield investment and we should not allow brownfield. So if we are working to attract FDI, we should attract such FDI which has a greenfield, which set up something new in your country, rather than it just acquires something which is brownfield. So from investment perspective or attracting investment perspective, we need to demarcate between greenfield investment and brownfield investment. I think.
I've been thinking a little bit here while sitting here. What I tried to propose these different arenas or levels of competition, and I think this competition for attention is something. I mean, I didn't invent that. That's Tim Wu and Evans, and even the chief economist at Google has discussed this. And of course, having a huge market like that implicitly implies that there's no market power. I mean, no one can control that market. But it also implies that everything is horizontal. Nothing is vertical. Everyone is competing with everyone. While you have ecosystems where you do actually can see someone controlling someone else, where there is firms that put terms in the contracts which can be seen as anti-competitive, where you see exclusionary conduct. So you can measure the power somewhere else than the market. You see what I'm saying? We skip markets, talk about arenas, talk about an attention arena and an ecosystems. And then we split that. And then we don't need to talk about verticals. Yeah.
I think that's particularly interesting. I think this discussion, and I think it's very different, Björn, if you just allow me to jump into your discussion with Filippo. That is, I think it's very different from GT Sylvania. I think it's very different from old economy, just channels of distribution. Because when you're building ecosystems and you're using these network effects to reinforce the powers within the ecosystems, these are very different levels of competition, the attention competition that we're mentioning and the competition within each one of these ecosystems. You can have different levels of competition happening at the same time. And I think we're still trying to understand how these levels interact among themselves. I think that's one of the issues. I'm not sure I can grasp entirely, but I'm not comfortable with the situation that, well, if there is inter-platform competition at any level, it's fine. We don't need to get into inter-platform competition. But I think that's much food for thought today and the next few days. If you want to comment, it's fine, but it's not a question. It's just a comment.
You should think before you speak. But now I spoke before I thought. But this is an informal session. But I'm very happy that you agree to a little bit.
No, I think it's interesting. It's interesting to think about it in this perspective. So let's move for lunch. We're precisely on the time that I got here, so I think we're on track here for the next few steps.